And Kevin Kline, I learned a lot about Kevin Kline. One thing I learned about Kevin Kline is that he likes to walk around with his rowboat. For me, I learned more than I needed to ever know about Mr. Kevin Kline.
Hey besties, Blake Lively's attorneys waited until the very end of the business day, the literal close of court, to make their move on the now infamous audio. You know, the one Blake claims captures Steve Sorowowitz bragging about spending $100 million to destroy her. That same recording, allegedly made without Steve's consent by Claire Aub, the director and writer of Empire Waste, produced by Wayfair Studios and released in fall 2024. Here's where it gets messy. Blake's legal team had this audio for months but never actually filed it with the court. Not when they pushed their motion for sanctions. Not when they asked for treble and punitive damages under Section 47. 1. Nothing. And now, as of today's filing, it's official. The court never had a copy. Not the clerk, not opposing counsel, not even the judge. No one. Earlier this week, the judge finally called them out, saying, "We're getting public record requests about this audio that was supposedly unsealed, but we don't have it." What's going on? So in response, Blake's team filed a letter saying, "In accordance with Your Honor's October 15, 2025 order, Plaintiff Blake Lively and defendants Wayfair Studios," and that's where things start to get even more complicated. Hey besties, Blake Lively's lawyers waited until the last possible moment, literally the end of the court day, to reveal what they plan to do about the audio. The same audio Blake claims captures Steve Sorowowitz boasting that he'd spend $100 million to destroy her. It was allegedly recorded without his consent by Claire Aub, the director and writer of Empire Waste, a Wayfair Studios film released in fall 2024. But here's the twist. Blake's team had this recording all along and never actually filed it with the court. Not with their sanctions motion. Not with their request for treble and punitive damages under Section 47. 1. Today's filing confirmed it. The court never had the audio. Not the clerk, not the defense, not even the judge. Earlier this week, the judge noticed the omission and said, essentially, "We're getting public record requests for the unsealed audio, but it's not in our system. You need to tell me what's happening." In response, Blake's attorneys filed a letter stating, "In accordance with Your Honor's October 15, 2025 order, Plaintiff Blake Lively and defendants Wayfair Studios." And that's where this story takes a turn. Blake Lively's attorneys, in their latest filing, respectfully write to inform the court of their efforts to publicly release the audio files that were submitted in support of Ms. Lively's motion for fees and damages under California Civil Code. For the one audio that the court had previously ordered unsealed. According to the letter, the parties have conferred and agreed to deliver copies of the physical audio recordings to the clerk's office in CD format. From there, the clerk's office will make the recordings available for public distribution or duplication upon request. Counsel for all parties confirmed that the clerk's office is amenable to this process, which they agree ensures proper public access to the audio while resolving the technical limitations that prevent such files from being uploaded directly to the court's public docket. The filing also notes that, while requests for the audio have so far been limited, counsel intends to provide a sufficient number of copies to accommodate any anticipated public interest. The agreement, according to the filing, is simple. The parties will deliver a CD copy of the audio to the clerk's office and provide additional copies as needed. The clerk has already agreed to this approach. But what's ironic, honestly baffling, is why this wasn't done months ago when the motion was first filed. If they had just included the CD back then, we wouldn't be in this situation now. How was the judge even supposed to review an audio exhibit that never physically existed in the record? It raises a lot of questions. What makes it even stranger is the basic legal protocol. Typically, to admit an audio recording into federal court, it has to be authenticated, to prove it hasn't been altered, to establish a clear chain of custody, and to confirm that what's being presented is accurate and original. Normally, that process requires a sworn statement outlining how the recording was made, who handled it, and that the file is genuine. Alongside that, a written transcript is crucial so the judge and jury can actually understand the context of the recording. Courts even accept digital formats like MP3, WAV, or MP4, and allow electronic uploads in addition to physical CDs. So the fact that none of this was done, no digital file, no transcript, no authentication, makes the entire situation even more questionable. Normally, when you submit an audio recording to the court, you don't just hand over a CD. You also provide a written transcript and a documented chain of custody to verify authenticity. Without those, there's no proof the recording is genuine. It could easily be considered hearsay. In this case, all Claire Aub reportedly said was that she recorded it because of X, Y, and Z. That might be an attempt to authenticate it, but she never explained how it was recorded. Did she use her phone? A voice memo app? A tape recorder? Was it captured over Zoom? No one knows. And that uncertainty matters. Even if the audio is eventually released to the public, it's still unclear whether it would ever be admissible in court. We haven't even reached that stage yet. Before it could be introduced at trial, the court would have to determine that it's relevant, properly authenticated, unaltered, and legally obtained. What's especially strange is that Wayfair isn't fighting the release. They're actually agreeing to make it public, which could mean they're confident the audio isn't as damaging as Blake suggests, or that they're quietly acknowledging its authenticity. Either way, it's important to remember. Right now, this audio is just an exhibit supporting a motion. It hasn't been admitted into evidence for trial. There's still a long legal road before it could be considered legitimate evidence in court. Meanwhile, the judge issued 2 overlapping orders touching on this issue. One involves the New York Times, which has asked for a final judgment dismissing them from the case. The judge responded that he doesn't think it's the right time for that yet. He reminded them that their dismissal is already final, but that there are still outstanding motions, specifically motions for attorney's fees, that need to be resolved first. The court has now asked every party to clarify what motions remain active and whether those filings mean the case is still technically open. Only then will the judge decide if the Times can be fully discharged. According to his order, the paper's request rests on a mistaken notion that the dismissal of the original complaint won't be final until a broader decision is rendered in the lively action. In reality, both matters have been consolidated, and their legal fates are now more intertwined than either side seems willing to admit. The court's order consolidating this case with the lively action did not, as some assumed, mean that the timeline for appeal would depend on a final judgment in both cases. Rule 42 doesn't work that way. As the Supreme Court has clarified, even when cases are consolidated, each one retains its separate identity, meaning that a final decision in one case can still be appealed independently by the losing party. Because of this, the judge has now ordered all parties to show cause and explain whether they believe the presence of unresolved motions for fees means the case is still open. Essentially, everyone involved must state whether they agree or disagree that the case is final, or alternatively, whether the New York Times can be discharged now. The issue is complicated by how federal courts typically handle consolidated actions. Usually motions for sanctions or attorney's fees aren't decided until all related cases have been resolved. But in this situation, the New York Times stands apart from the other defendants, so the judge wants clear answers before making any ruling. Their responses will determine whether the paper's dismissal can be finalized or if it remains tied to the broader Lively action. Circling back to the CD issue, the judge has now given Blake Lively's team a hard deadline. Monday, October 20th, 2025. By that date, they must provide the court with a physical copy of the recording. No extensions, no excuses. But what still doesn't make sense, and what keeps coming up, is why this wasn't done from the beginning. When they filed the original motion, they should have included a copy of the CD immediately. Instead, they waited months, only to now hand over a physical disc that the clerk will need to duplicate manually. It's not the most efficient or transparent way to handle evidence that's already been unsealed and requested by the public. The problem with the CD plan is simple. It's outdated and unnecessarily complicated. In 2025, there's no reason a federal court shouldn't be able to handle a simple digital upload. They could have easily shared the file in WAV or MP3 format through the court's electronic system. Instead, this approach forces the public to jump through hoops, physically going to the courthouse, filing a request with the clerk, paying a fee, and then receiving a CD that most people don't even have a player for anymore. Sure, I technically still have an external drive on my laptop, but I'm not about to request a CD by mail from New York. It would take weeks to arrive. Realistically, someone on Reddit will probably beat everyone to it. Show up Monday or Tuesday, grab a copy from the clerk's office, and upload it online. And that's what's so frustrating. Blake's team could have just released the audio themselves. They could have said, "We're making this public. Here's a verified WAV file on our website." But they didn't. Maybe they're worried that if they publish it directly, it could raise legal issues about whether the recording was lawfully obtained. So, by handing it over to the clerk's office, they remove themselves from that liability. The clerk handles distribution, not them. It's technically smart, but it's also incredibly evasive. What this all points to is a larger question. Did they ever really intend for this motion to have legal weight, or was it just a PR maneuver dressed up as a filing? Because anyone who's ever been through litigation knows, you submit your evidence when you file your motion. You don't hold it back, you don't hide it under seal, and you definitely don't make the court chase you for the material you claim supports your argument. Judges don't have access to discovery files. They rely on the evidence you give them, and in this case, Blake's team didn't give the court what they said they had. That's not just sloppy, it's strategic. Discovery, as most people forget, happens entirely behind the scenes. Judges don't automatically get access to discovery files. They only see what's formally submitted as evidence through motions and hearings. What's eventually admitted into court goes through a process called motions in limine, which determine what's allowed or excluded from trial. Until then, even sealed documents marked attorney's eyes only are off limits to defendants and the public alike. So if Blake's team originally filed this audio under that label, it means that until the court unsealed it, Steve Sorowowitz, Bilan, and the others named in the filings never actually heard it. In fact, until a physical copy is provided to the court, the recording is still technically inaccessible. The attorneys might have heard it privately, but even they may not have a physical copy yet. That's where things stand right now. It's strange, almost absurd, that in 2025 they're relying on a CD to share evidence. Maybe it's a technicality, maybe it's intentional, a way to slow things down, to add friction before the public hears what's actually on the tape. Either way, come Monday, the CD will finally reach the court. And if the rumors online are true, someone from Reddit, apparently a user named Clark, is already planning to be there the moment it's available to grab a copy and post it online. What's actually in the audio, whether it's relevant or whether it will ever be admitted at trial, all of that remains to be seen. For now, Blake's argument is that it proves a conspiracy to take her down. Whether the tape supports that claim or unravels it entirely will soon be clear. Thanks for watching, besties. Don't forget to drop your thoughts in the comments, give the video a thumbs up, subscribe if you haven't already, and click the bell so you never miss an update. Bye, besties. Bye, besties.